That was a really interesting presentation, as well as Amanda. I just want to quickly say, I see there are a couple questions coming in already. And remember, we're here to answer the questions, but try not to ask sort of like specific legal questions. We're not here to answer legal advice on specific specific fact patterns, etc. So continuing, it is my turn to discuss European updates. So why are we doing this? Beside the fact that many of our DMLA members are international companies or work in Europe, Europe is really a leader in driving legislation that impacts our industry. Along with the US, which is also a leader, but as we've seen with things like GDPR in the past, Europe has the ability to sort of set laws that then become standards for the rest of the world. And I think it is important to follow closely what's going on. So this is not intended to give a update on everything that's going on in Europe. We're going to focus on three things. One of the first one's the copyright directive. The second is what's going on with AI and disinformation. And the third is a relatively new initiative called the Digital Services Act. So the first thing is the EU Copyright Directive. It's also sometimes referred to as the DSM, or Digital Single Market Directive. Now, I don't want to go too much into it. I know that that Margaret discussed this last year and gave a background. But to give a little bit of context, it came into force in June of 2019, and that was the end result of quite a bit of back and forth between stakeholder groups and lobbying to get the law put into place. Now, there were part of the law is that there was 2 years to implement. So that gives us up until June 2021, where all of the member states have to implement the directive into their national law. So there's still some time, obviously, but we're getting up to it. And then another important thing to remember is that this act was supposed to be a balancing act. It's not just for rights holders. Platforms or OCSSPs, online content sharing service providers, we're also supposed to get the benefit from this. They're supposed to be able to use copyrighted content and profit from it. Now, there are many articles in the copyright directive. And here I'm really just going to focus on one, Article 17, which is probably the most important to our industry. And it has also been one of the most controversial. Now, so just to give a little bit of background on what that is, it was intended to fill what, what we were calling the value gap. Now, that value gap is really where platforms have been able to take copyrighted content uploaded by users and benefit financially from it, and without remitting any sort of payment to the copyright holders. Now, sorry, go back to that slide. And so this is really intended to do that. And what Article 17 does is it puts an obligation on these platforms or OCSSPs to have to use their best efforts to obtain authorization from rights holders to use the copyright content that is uploaded by their users. Now, so what happened after the law came to force back in 2019 is the EU Commission set out these stakeholder dialogues. And they were well attended. There were representatives from rights holders. Getty Images participated, as well as a bunch of others in the industry. Platforms were also there, and then also user groups were represented. And the result of that, those stakeholder dialogues, is that the commission took all of this dialogue and published its guidance, and that came out this summer in July 2020. I'll talk a little bit more about that. So actually, before I talk about that, part of the Article 17 implementation, as I said, is that each country has to implement into their own law. So before the EU Commission came out with their proposed guidance, the Germans actually they published this draft act back in September, and that was not received especially well by the rights holders community. There is definitely a sense that that they had really taken into account what the user groups and the platforms had said, and maybe went a little bit further than what the DSM actually has in it. So they included a couple things like an exception for basically de minimis use, and in our industry, it said, for non-commercial use, any image that's below 250 kilobytes would not be subject, and that's not in Article 17 anywhere, which is a little odd. And then they also came up with this new idea of flagging, of basically a user being able to say pre-flag material saying this is licensed, or it's not subject to the law, which is a little bit outside of what Article 17 said. So there was some backlash to this. Our friends at BVPA submitted a really good commentary on it, and from what I understand, that actually the Germans have published another revision of this. I haven't actually seen a translation of it yet, but I hear that there are some significant changes. So we'll see what happens there. Also, as I said, the EU Commission, they published their proposed guidance. And from a rights holder's perspective, this, again, a lot of people felt that it went a little bit too far, and that it interpreted the law instead of giving sort of guidance on how to implement. I think the best example of how they went too far was really embodied in the French response. So the French authorities, they put out an official response criticizing the guidance and saying that it was it proposed way too many exceptions that aren't in the law. And they were saying that it's more of a legal interpretation rather than implementation guidance, favoring the platforms, and it really puts the intended balance of the directive out of whack. Again, we'll see what happens. It is certainly up in the air how the guidance will be implemented, and I think that there is a lot of controversy to come. But as I said before, it should be implemented by June of 2021, and at that point, we will all have to figure out how to deal with each country's individual law. So there are a couple outstanding issues that I think are important in our industry. So extended collective licensing. So the German implementation talks about this a bit. And it's not specific to our industry necessarily, and extended collective licensing, or ECL, works in some other industries well, such as music. But it has never really been something that our industry has been able to adapt. And I think, for example, the UK has had ECL since 2014, but there's not been any licenses issued under that. Why? I think there's a lot of issues. I think, the fact that a lot of the content is non-exclusive is one of them. There are many, but I think that is something that we're going to have to figure out. One thing that can help figure that out is technological tools. So at this point, I think that it's pretty clear that tools that can identify content it's almost a commodity that it gets used in our industry all the time in terms of compliance operations, and the technology is there. But one of the problems is, and this was brought up in the stakeholder dialogues by the user groups, and they've had their voice, is that there's this concept of overblocking. And there is the idea that these tools can't necessarily tell context. And so while some use may be permitted by the law, the matching tools that we have now are just finding matches, and that there is really no way yet without humans to determine the context and see if something is an exception. Now, I think that this has obvious global reach. That the technological tool issue that I was talking about also comes into play when we're talking about the U.S. And revisions to Section 212. And I think that we will see a lot of the same issues. I think that it's really important to watch where this goes, because as the U.S. tries to make reforms, I think that it will only make sense to look and see how the implementation of Article 17 went. Okay, so next update is AI and IP. So what is the EU doing in this space? So they've been thinking about it for a couple years now. There is something called the AI Alliance, which was launched back in June 2018, and it is bringing together legislators and industry to sort of talk about the issues and think about regulation. They just had a recent assembly a couple weeks ago, which was really interesting, and I think that thought there is developing a lot quicker than what you see in the U.S. right now. And what they are really trying to do is what they're calling building an ecosystem of excellence and trust in AI. And so that has a lot to do with, encouraging innovation, but responsible innovation. And they published a white paper on AI, which is a really good read if any of you are interested. And that deals with the technological, ethical, legal, and socio-economical aspects of AI. There was an open it was an open consultation, and they received over 1,000 replies, including Getty Images that replied to it. And they will the EU Commission is going to have recommendations coming out of it coming soon. So it's a good idea to be looking out for what that is. I think one of the interesting things that come out of there is they are thinking about regulatory framework, but only using it for what they're calling high risk applications. And so what that definition of high risk is something that we all need to watch as an industry. Disinformation or synthetic content may be one of those things that gets regulated as a high risk application. And finally, the committee, the jury committee is also looking into this. So the white paper really didn't talk that much about IP and AI. And that is something that rights holders, Getty Images, we really brought out in our comments. And I think we're getting some traction with getting the Europeans to think about this a little bit more. And so jury report, they just voted on this and adopted the report, which really brings in a lot of considerations related to IP, and that will move forward. They have a special committee on artificial intelligence, and that committee will be considering IP implications. So what are some of those issues that are being addressed, specifically related to IP? And I talked about some of this in the synthetic content panel that we had earlier today, but I'll go through it again. So one of the key issues for our industry is that copyright had to be protected. In many applications of machine learning, copyrighted content is data, very valuable data that can be used. And so if copyrighted data is being used, we want to make sure that whoever's using it is obtaining proper authorization. And that is, I think it's important. And I think that the Europeans have understood that, and they're moving forward with at least resolutions that make that clear. And it's consistent with their idea of protecting IP as a fundamental right. So IP is considered a fundamental right in the EU. It's part of the EU Charter of Fundamental Rights, and I think connecting it to sort of this ethical background related to AI is clear. So you want to protect fundamental rights, and IP is one of them. And then, there's some other sort of basic issues. Can AI created work as synthetic content be protected? This is in the patent context and in the copyright context. Is there enough human involvement to meet the standards for protectability? I think that there's some very good thought on that as well. And then, a big issue is disinformation and synthetic content. And this is something that the regulators in Europe are very, very concerned about. And as I said before, this might be something that is considered high risk application, and then therefore would be subject to some sort of regulation. Not really clear what that regulation would be. Part of, what I think is good policy is the maintenance of auditable records related to any sort of high risk application, and that is something that the Europeans have embraced. And so, what that really means is, if, for example, if you're going to be using copyrighted content as underlying data in your for machine learning, you keep a record of what you used. You don't necessarily need to disclose it, but it has to be auditable in case there is some issues down the road. And then another thing that they need to look at finally is clarifying the text and data mining exceptions from the DSM. As I said before, the DSM is a balance, and there are exceptions in there that allow for text and data mining for certain things, but it also makes it clear that a rights holder can opt out of that for commercial purposes, and so it's important that does not get lost. Okay, so then finally, I wanted to just talk about the Digital Services Act, or DSA. Now, I think this is what they're saying. The new commission that came in recently, this is what they are really pushing for. And the reason I'm really bringing it up here is that the commission is not really interested in passing another copyright directive. So if there are any issues that are important to rights holders, they're most likely going to be addressed in the DSA. And this is a wide-reaching regulation on online platforms. So, it goes beyond just the platforms that the copyright directive talks about. And it could impact many of the DMLA members as platforms as well. And so they're trying to really protect users from these big platforms who many think have gotten too much power, and allow for innovation from startups, etc. One interesting piece is that it covers marketplaces, which is a type of platform that's completely left out of the copyright directive, and a lot of rights holders were upset about that. And so, this is really the place, if there is going to be sort of copyright reform about what marketplaces can and cannot do with copyright material, it will probably get put in here. Another thing, it's reviewing the liability regime. of digital services acting as intermediaries. I think that's relatively self-explanatory. And again, as I said, they're talking about really trying to limit the power of these big internet companies that are really like gatekeepers of digital platforms, and trying to sort of bring more balance back to the internet. It's interesting from a U.S. perspective that this connects a lot to what you may hear about Section 230 reform in the U.S., and a lot of the same issues are going to be coming up. So if you're interested in 230, you should probably also look into DSA. There was a very extensive public consultation on this that closed in September. They have not released a report on the consultation, but it will be very interesting to see what direction it is. And I think it's a sort of wait and see to see how it will impact our industry. So that's all I have